This is Bloomberg Law with June Grasso from Bloomberg Radio.
The answer is I always abide by the courts, always abide by them, and will appeal. I never did defy a court order. Well, I always abide by the courts, and then I'll have to appeal it.
President Trump has said repeatedly that he always obeys court orders. But critics say there's evidence that his administration has not been obeying court orders, even those of the Supreme Court. And it appears the justices have had enough. Thus, the Supreme Court issued an emergency order with incredible speed in extraordinary circumstances. Last Saturday at 1 a.m, within just 8 hours of getting an application, before the government had time to respond, before the Fifth Circuit issued its ruling, and before Justice Samuel Alito could finish writing his dissent, the Supreme Court ordered the government not to deport any of the Venezuelan detainees until further notice. And only the two most conservative justices dissented. My guest is constitutional law expert Michael Dorf, a professor at Cornell Law School. Mike, this order in the middle of the night, without following normal procedures, like waiting for the government's response and the Fifth Circuit's decision and Justice Alito's dissent, does this show that the justices don't trust the Trump administration to obey their orders?
Absolutely. The court had, in an earlier case, said that the government should not remove any of the Venezuelans without first giving them notice and an opportunity to file a habeas corpus petition. Here, the Venezuelans who are being held in Texas received notices in English, which most of them don't speak or read, saying that they would be removed imminently. There was no mention of the right to file a habeas petition. And so when the federal district judge didn't act within just over 2 hours, the lawyers realized that the government might move the case by taking these people out of the country, sending them to El Salvador. And so they went to the Supreme Court seeking emergency relief. The fact that the justices acted when they did in the middle of the night so quickly without a response, as you say, I think clearly indicates at least 7 justices felt the same way as the lawyers did for these Venezuelans, namely the government couldn't be trusted to abide by the justice's previous command.
It was a short order, 11 lines, no explanation. But Justice Alito's scathing dissent was 5 pages. He objected to granting what he called unprecedented and legally questionable relief, saying, "We had no good reason to think that, under the circumstances, issuing an order at midnight was necessary or appropriate." Does this mean he still believes that the Trump administration is listening to orders of courts?
Well, it either means that he believes that or he doesn't care, right? I mean, he might think that whether or not the administration is going to comply, we, meaning the court, have to abide by our procedural rules and dot every I and cross every T. In fact, what he said at the end of his dissent was, the executive branch needs to comply with the law, but so do we. What he didn't say, of course, was, well, what happens if the executive branch isn't complying with judicial orders? Does that mean, as the majority clearly thought, that you take extraordinary measures?
President Trump and the administration continue to say that they'll follow court orders, they're obeying court orders. Trump did complain Monday on being stymied at every turn by the courts and said the administration can't hold trials for every detainee they want to deport because it would take 200 years.
First, I think it's inarguable that they are not fully complying with orders of the lower courts. And there is pretty good evidence that they are not complying in good faith with the Supreme Court. So in addition to not giving the Venezuelans the notice to which they are entitled, the administration in the Abrego Garcia case has flatly refused to comply with its obligation set by the Supreme Court to facilitate his return. With respect to the president's claim that, giving these migrants due process would be a too onerous burden, that assumes that what they're entitled to is a kind of full-dress criminal trial. But that's not true. There are statutory guidelines that allow for very much expedited hearings, but they do require some kind of a hearing. You can't just, have people in unmarked vans scooping people up off the street and then shipping them off to a foreign country that's not even their home country when there are, as in Abrego Garcia's case, court orders forbidding that, or as in some of these other cases, no real evidence that they are subject to deportation at this point. Now, having said that, President Trump is right that if he were to attempt the kind of mass deportation of everybody in the United States who entered undocumented, that it would be difficult to do that in a timely manner because there are procedures that have to be followed. But he also doesn't have the manpower, he doesn't have the budget to do anything like that anyway.
Trump and the administration have been steadfast in saying that they're not going to bring Garcia back, but they're also blaming it on the president of El Salvador.
Yeah, I think that is in pretty clear defiance of at least the federal district judge's order. Now, you can say that in the earlier case that all that the Supreme Court did was to ask the federal district judge to clarify what she meant by facilitate. But, the court pretty clearly approved of the obligation for facilitation. And, there was a remarkable decision by a unanimous three-judge panel of the Fourth Circuit in which Judge J. Harvey Wilkinson III, who's a very conservative appointee of Ronald Reagan, really called the administration to task for doing literally nothing to facilitate Abrego Garcia's return and warned in pretty ominous terms of the potential death of the law here. So, in the face of that, the Trump administration is continuing, nonetheless, to, simply not do anything for Abrego Garcia. And what's so remarkable about this is that, they could say, well, we're going to comply and then ask the president of El Salvador, hey, can we have Abrego Garcia back? And he might then say, well, no, I'd really rather keep him because, after all, he is an El Salvadoran national. Now, it's true, we sent him back there by mistake, and there was a judicial order forbidding that. But that order doesn't bind the government of El Salvador. But the Trump administration isn't even willing to ask, and they could ask. This wouldn't be good faith compliance, but they could ask while winking, and then they could go back to the judge and say, well, we asked, and he said no. But they're not even willing to do that because they see this as a matter of power politics.
Until now, the conservative justices have been giving Trump narrow procedural wins that have allowed him to, for the most part, run his agenda. Does this mark a turning point in the majority's approach to the administration?
I hope so. I have been highly critical of the Roberts Court for some time now for treating Donald Trump as an individual and his administration in their official capacity, treating them the way you would treat any president who, occasionally pushes the edge of the envelope of their authority, but then when subject to a ruling complies, which has been true of every Democratic and Republican president, for as long as we can remember, excepting extraordinary circumstances like Lincoln during the Civil War, something like that. The one that was sort of most disturbing to me was the immunity ruling last year, in which the court said, well, we don't want to hamstring the president because in the future there might be, sort of tit-for-tat retaliation against former presidents. That could lead to all sorts of trouble. Sort of thinking about the long term and ignoring what is essentially an emergency right in front of them. And I was a little concerned that was what was going on in the last few months as this second Trump administration proved to be much more radical than the first. But it looks like, and I'm hopeful that, the court is beginning to realize that they're not dealing with a normal law-abiding president and administration, but a person who's seriously threatening constitutional democracy, and that they need to stand up to him.
The court announced a special session on May 15th to hear arguments on Trump's executive order upending birthright citizenship. Why would the court agree to hear a case like that outside its regular schedule, when all three lower courts that considered it ruled against the administration, finding the executive order unconstitutional?
Well, the court did not take the case to decide the substantive issue. The Solicitor General didn't even ask the court to decide the substantive issue. All that the court is deciding is the authority of a federal district judge to give a so-called nationwide injunction. That has been a long-running source of controversy, actually in both Democratic and Republican administrations. It's been frustrating to presidents of either party when a single federal district judge, often selected by the plaintiffs because they know their ideological leanings. You can do a little bit of forum shopping or even judge shopping by deciding where to file. But a single district judge sort of sets nationwide policy, at least for the short run. And so some of the justices have for a long time been concerned about this phenomenon. I think that it's extremely unlikely that the court will, in this case, rule on the birthright citizenship issue as a substantive matter. Now, that doesn't stop the media or actually even President Trump from portraying this as something else entirely. So, as soon as the court announced that it was going to hear argument, Trump said something like, well, this is very misunderstood. That's about slavery, he said. By that, he was referring to the birthright citizenship clause of the 14th Amendment. So he seems to think, or at least he's saying, that this case is about the substance, but it really isn't.
And it may actually lengthen the Supreme Court's term. Thanks so much, Mike. That's Professor Michael Dorf of Cornell Law School. Coming up next, the Supreme Court considers parents' religious objections to LGBTQ-friendly children's books. I'm June Grasso, and you're listening to Bloomberg. Uncle Bobby's Wedding is the story of a same-sex wedding where a niece worries that her uncle won't have as much time for her after he gets married. It's one of a handful of children's books with LGBTQ characters at the center of a Supreme Court case. But the oral arguments seem more like a contentious book club when liberal Justice Sonia Sotomayor and conservative Justice Samuel Alito gave competing interpretations of the book, and the Chief Justice had to intervene.
Two men, little Bobby's Wedding, where they're getting married. One is black and one is white in this rendition of the book. I had one with mice. The two male mice looked identical to me. Is looking at two men getting married, is that the religious objection?
I don't think anybody can read that and say, well, this is just telling children that there are occasions when men marry other men. Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this. Everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute. The reservation is about...
Can I finish, please? It has a clear moral message.
Just answer my question. Is looking at the pictures, is there any affidavit from any parent that merely looking at people getting married, holding hands, none of them are even kissing in any of these books. The most they're doing is holding hands. That mere exposure to that is coercion.
Welcome back to the culture wars at the Supreme Court, where several parents are objecting to incorporating the LGBTQ-friendly books into the elementary school curriculum on religious grounds. And after 2.5 hours of oral arguments, it seems clear that the conservative justices will rule for the public school parents. My guest is First Amendment law expert Caroline Mala-Corbin, a professor at the University of Miami Law School. Caroline, these books are not about religion. They're stories with LGBTQ characters.
Yeah, so basically the case that the Supreme Court heard oral argument on Tuesday morning concerned a religious liberty challenge brought by parents who argued that they had a constitutional free exercise right to prevent their children from reading books with LGBTQ characters. And from the tenor of the argument, it does seem quite likely that the Supreme Court will agree with them and grant them this as a constitutional right.
Do the conservative justices readily accept the idea that these books about a same-sex wedding, about a puppy that gets lost at an LGBTQ pride parade, and a young child whose gender identity doesn't match his birth-assigned sex, that these books violate the religious beliefs of the parents?
So definitely the parents bringing them are religiously conservative, although they're not only Christian. I think there are also some Muslim parents as well. And the justices very much accepted the idea that having children read these books would impose a substantial burden on the parents' free exercise, which is a stunning expansion of what it means for the government to impose a substantial burden on someone's religious exercise. So originally, when we thought about government-imposed burdens, it would be something like the government is preventing you from observing a tenet of your faith. Like the government made it impossible for you to observe your Sabbath or participate in the sacramental use of peyote, something that was really a central religious practice. The Roberts Court has already expanded what counts as a substantial burden to not just view yourself violating a religious tenet, but for someone to endorse or facilitate a third party's violation of religious tenets. So we have the Supreme Court being very sympathetic to people who argue that baking a cake for a same-sex wedding would be akin to endorsing the sin of same-sex marriage or facilitating the sin of same-sex marriage. That first expansion was itself already quite a broad reading of what counts as a substantial burden. But what we may see after the Supreme Court hands down its decision in this case is just hearing about people who act in a way that's contrary to your religious tenets suffices to be a substantial religious burden, because that's ultimately what's going on in these public schools. The children are hearing about the existence of two men getting married, or they become aware that there are transgender people in the world. And if that information is not accompanied by a condemnation of it, then it seemed like there were 5 justices who thought that that could amount to a very serious infringement on the parents' free exercise rights. I am willing to bet that there are at least 5 justices who thought that there is a free speech violation here.
So what were the main concerns of the conservatives?
The main concern was that they were hearing about LGBT community without hearing a condemnation of it. And therefore, in their eyes, that equates to indoctrinating their children into accepting gay people or transgender people. And that is contrary to their own religions, which condemn them.
Justice Sotomayor said, haven't we made it very clear that the mere exposure to things that you object to is not coercion? And then she talked about this book, Uncle Bobby's Wedding, and she said that none of them are even kissing in any of these books. And then Justice Alito actually read from the book saying there was a clear moral message.
His argument was this book not only articulates that these people exist, but it also conveys the message that these people are people and they're okay and there's nothing wrong with 2 men marrying each other. And that is what he equates to indoctrination of children in the classroom, which of course is not the only way to think about what those books are doing. One of the central goals of the public school system is to train children to live in a democracy. And one of the preconditions for us all coexisting together is that we learn that we're not all alike, and that even if there are people who are different from us, we should still treat them with dignity and humanity and accord them the same respect that we ourselves would like to receive. And so I think the reason the school included these books in the first place is to try and teach that very basic civic lesson to little kids. But that message that these books, again, they're surprisingly innocuous. I think the main point of Uncle Bobby's wedding was that she was a little upset her favorite uncle might get married and she wouldn't get to hang out with him anymore. And the message she learned is she didn't lose an uncle, she got another one. You know, that kind of message you often see in children's books. But again, the very presentation of the LGBT community as regular people who we should not condemn as doing something against, God's orders is considered to be unacceptable to the religiously conservative families.
And the author of Uncle Bobby's Wedding, Sarah Brennan, told Slate that she was dismayed by the way Justice Alito characterized the book and that Justice Sotomayor really understood the book's message. And all three of the liberal justices focused on the line-drawing problems presented by this case.
Because, again, the principle that they were arguing for is if there is something in the curriculum that a religious parent objects to on the grounds that it is contrary to their own faith, that they have the right to know in advance that it's going to be taught and the right to pull their children from the classroom. So there was no limit by age. There was no limit by subject matter. And of course, we live in a magnificently diverse country where people have all different kinds of beliefs. And so there was one line of questioning is, well, what if parents object to interracial marriages? Do they get notice? And what about if some object to interfaith marriages? What if some belong to religions that oppose having women who work outside of the home? Are they now entitled to notice anytime there is a social studies class or a literature class that features a woman who's worked outside of the home? What about parents who believe in the literal interpretation of the Bible and take that to mean that evolution is false? Does that mean that they can pull their kids from the evolution section of a biology class? Or, and this is another question that was asked, what if a parent objects to a teacher using the appropriate pronouns for a transgender child in the class? Does that mean that they can say, I don't want my child in this class, I'm entitled to a completely different teacher? And the lawyer for the parents did concede that, yes, there were some parents who would find that to be a substantial burden on their own religious exercise if the teacher uses appropriate pronouns for another transgender child in the class.
So what's the question the court is going to answer?
Well, the question before them is, are these parents entitled under the Free Exercise Clause to have the right of notice and the right to opt their children out? How the court gets there may depend on which route the court takes. We've been focusing on a very traditional one where the court says, well, this law is not neutral and generally applicable. It's sort of targeting religion. Second is, does this book impose a substantial burden on the parents' right to practice their religion? And finally, is there a compelling government interest that everyone read this book? And is there no other way the school can accomplish its really important government interests that don't infringe on the religious parents' rights? So one way or another, the court is going to say this infringes on people's religion, and the government can't justify insisting on reading these books because ultimately they could read other books.
So we'll see which way the justices get to that seemingly inevitable conclusion. Thanks so much, Caroline. That's Professor Caroline Malak-Corbin of the University of Miami Law School. Coming up, Sarah Palin loses her defamation case again. I'm June Grasso, and you're listening to Bloomberg. Former Alaska Governor Sarah Palin became well known in 2008 as the late John McCain's vice presidential running mate. She also became well known for a series of verbal slips, gaffes, and generally cringeworthy moments.
They're our next-door neighbors, and you can actually see Russia from land here in Alaska.
Obviously, got to stand with our North Korean allies. We're bound to by treaty. We're also bound by, yeah.
I told Congress thanks, but no thanks for that bridge to nowhere up in Alaska.
Since then, Palin's star has gradually faded, although the spotlight returned to her in 2017 when she sued the New York Times for defamation over an editorial. But this week, for the second time, a Manhattan jury found that the Times did not defame Palin. Joining me is an expert in First Amendment law, Samantha Barbas, a professor of law at the University of Iowa College of Law. Tell us why Palin sued the Times.
So this story goes back to 2011 when there was a tragic shooting of Representative Gabby Giffords in Arizona. And 6 years later, there was another tragic shooting at a baseball game in which various Republican politicians were participating, and a congressman was hit. And the day after that, the New York Times ran an editorial in which it suggested that there was a link between kind of violent political environment that various people were promoting and these tragic mass shootings. In particular, it pointed to a digital graphic that had been produced by Sarah Palin's Political Action Committee, I think back in 2011, around the time of the Arizona shooting. And that graphic used crosshairs to target various congressional districts that I guess Palin was interested in focusing on, interested in having her campaign focus on these Democratic political districts. But the New York Times suggested that that was actually kind of an incitement to violence, the use of crosshairs and, inciting people to take vicious action against their political enemies. And so the Times effectively linked that graphic to the shooting of Gabby Giffords in Arizona. And Sarah Palin said that this was false, that her Political Action Committee had nothing to do with the shooting, and that her reputation was injured, that she was defamed. And that's the origin of her libel claim against the New York Times.
This legal fight has been going on for 8 years now, and this is the second time that a jury has heard the case and ruled against her. What happened the first time?
Importantly, the standard here is actual malice. So because Sarah Palin is a public figure, she had to show that the false statement was made with reckless disregard of the truth, so that the Times either knew the statement was false and published it anyway, or had really strong reason to believe that the statement was untrue. So the first time, this was in 2022, during the trial, the evidence was presented about what the Times opinion page editor knew and did not know when this editorial was issued. And the Judge Rakoff, at the close of the trial, suggested that even if the jury found for Sarah Palin, he would set aside the decision. And while the jury was deliberating, apparently they were notified of Judge Rakoff's pronouncement that he would set aside the verdict. And some of them even got push notifications on their phones about this. They obviously found in favor of the Times, and Sarah Palin appealed, suggesting that these procedural irregularities merited a new trial. And that's why we had the trial that concluded days ago.
The person in charge of the Times opinion section admitted he'd made a mistake, said he acted quickly to rectify it. So was the main question for the jury whether he acted with reckless disregard for the truth?
Yeah. So again, the issue was, what did the Times editor know at the time he made the decision to publish this editorial? Did he know that these statements were false, connecting Palin to the shooting? Did he have strong reason to believe that the statements were false and nevertheless allow them to be issued? And so it's the Times argument that, we were careless, right? We made a mistake. We apologized. Our journalism was sloppy here, but we attempted to correct that as quickly as possible, and what we did didn't rise to the level of reckless disregard of the truth. It was merely negligent, and that's not sufficient in a libel case involving a public figure.
So did Palin's testimony relate at all to that question, or was it just about damages?
So Palin's testimony was about the harm that she alleged that she'd suffered. She said things like, it kicked the oomph out of you, I guess is the language she used, right, to describe how injurious these statements were to her sense of self, her emotional state. But interestingly, I don't think she was able to demonstrate that she'd actually suffered reputational harm. I don't think she lost any speaking engagements or book deals or anything tangible as a result of this allegation. But yes, her testimony was mainly on the harm that she had suffered.
So what do you think the message is when a second jury, after deliberating only about 3 hours, came back with the same verdict as the jury 2 years ago, that the Times didn't defame Palin?
Yeah, well, I think the conclusion is that actual malice is a very high bar to clear, and that it does a good job protecting the press in situations where there may be an honest mistake, a mistake that a responsible news publication goes out of its way to attempt to correct. And, actual malice says that that's not punishable. Now, there's the question of whether or not Palin will attempt to appeal this and whether this win for the Times will sort of fuel the momentum that's out there to get the Supreme Court to reconsider the actual malice standard. That's kind of lurking in the background of this.
I think Palin's lawyers said that they wanted to use this to attack the precedent, the landmark New York Times v. Sullivan case. Explain how that case has come under fire recently.
So the attack on New York Times versus Sullivan really started in earnest, I think, back in 2016 when Trump announced that he wanted to open up libel laws to make it easier for him and his allies to sue the press for libel. And I think what he was referring to was getting the Supreme Court to overrule New York Times versus Sullivan. So ever since then, there have been a number of conservative lawyers and activist groups and pundits who have been making this case, arguing that Sullivan is outdated, that it doesn't protect reputation enough, that it protects, the lying press, and that it needs to go. And these pundits and lawyers have been focusing in particular on some cases decided by the Supreme Court after Sullivan in 1967, when it extended the Sullivan actual malice standard to public figures. So Sullivan dealt only with public officials. And so the extension, sometimes called the progeny of Sullivan, really create a broad protection for the press against libel suits. But that has really been a target of these opponents. They want the court to get rid of that public figure standard or to limit the definition of who is a public figure. And, we may see that having increasing traction in the coming years.
You've written a best-selling book on the subject called Actual Malice. So do you think that the standard is too high for plaintiffs to clear?
No, I think that the New York Times versus Sullivan standard and the extension to public figures really strikes an appropriate balance between the protection of reputation and protections for freedom of speech and press. It is possible to recover for injury to reputation under our constitutional regime, right? If you can show this reckless disregard of the truth, you will be able to prevail. So it's not that libel law is dead, as some have said. It's just very difficult to meet the standard, and that's because we need to have a press that is free and robust, the court said in Sullivan, a press that can make an honest mistake in the course of gathering the news when, procedures may be time pressured. So I think, we have a system that's worked very well for the past 60 years that has really allowed a lot of important journalism to flourish, but still allows defamed people to recover when they can meet that standard.
I mean, I'm not sure how many people really followed this case. It did get a lot of publicity. Do you think the loss here encourages the movement to get rid of the New York Times v. Sullivan standard? What's the impact of a loss in a case like this?
Yeah, so I think they could point to this and say, there was clearly wrongdoing on the part of the Times. The Times admitted its mistake. Nevertheless, under our current constitutional regime, the plaintiff, Palin, could not recover, and they would say that's unfair, and that we need to kind of lower the bar to make it easier for public figures to recover when news media have been careless. So I can see this sort of playing into that campaign that argues actual malice is just too stringent a standard. It doesn't permit people who have been injured to get the compensation that they feel they deserve.
Americans' trust in the media continues to be low. Last year, for the third year in a row, a Gallup poll showed that more Americans had no trust in the media, 36%, than had trust in the media, 33%. So in this climate, is it a surprise that the jury came back for the New York Times, or is it not a surprise because we're talking about a jury in New York City, which has been called the media capital of the world?
Yeah, I think it was a little bit of a surprise. I mean, again, we have this trial taking place against a cultural and political backdrop that has not been very favorable to the press. I mean, the press is increasingly accused of not being objective, trustworthiness is questioned, and so I would not have been surprised to have seen a jury go for Palin. I think today, in libel cases, even when there's weak evidence of actual malice, the jury might be motivated to see reckless disregard of the truth just because of this distrust of the press that's so pervasive.
Any final thoughts?
I mean, I think that this could add to the momentum to overrule New York Times versus Sullivan in the progeny cases. And so I think those of us who are concerned with press freedoms are going to be watching this closely to see what happens.
I enjoyed our discussion, Samantha. Thanks so much for coming on the show. That's Professor Samantha Barbas of the University of Iowa College of Law. Her book is entitled Actual Malice, Civil Rights and Freedom of the Press in New York Times v. Sullivan. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.